Respected Shri Narendra Modi ji, the Prime Minister of India, Mr. Justice B.R. Gawai, Judge Supreme Court of India, Mr. Justice UMAKANT, Judge Supreme Court of India, Shri Arjun Ram Meghwal, Minister of State, Ministry of Law and Justice, Mr. R. Venkataramani, Attorney General of India, Mr. Manan Kumar Mishra, President Bar Council of India, Mr. Kapil Sibal, President Supreme Court Bar Association, Judges of the Supreme Court and the High Courts, former Chief Justices, former Judges of the Supreme Court, members of the Bar, distinguished audience, Namaste and a very good evening. 75 years ago, on 26 November 1959, a defining moment in India's history unfolded. The Constitutional Assembly adopted the Constitution of India. Today, we honor this historic occasion not merely as a celebration of adoption, but as an ode to living, breathing document that is the Constitution. We, the people of India, consider it to be a way of our lives. It is our pledge to honor, uphold, and protect Constitution of India as its trustee and custodian. The Constitution bestows upon the Constitutional Court the power of judicial review. This enables us to strike down amendments to the Constitution, the legislation, the executive policy, administrative and quasi-judicial decisions. We entertain public interest litigation, initiate suo motu cases, appoint amicus curiae to aid our decision making. The district courts, the first point of contact for most citizens, adjudicate disputes and in this manner enforce fundamental rights and other rights available in law. Sorry. The role of a judge is often likened to walking on a razor's edge. Each case we hear requires balancing competing rights and obligations with fairness, empathy, and precision. Every judgment we render is a zero-sum game. It inevitably creates winners and losers, inviting celebration from some and criticism from others. This is dual. This is the duality which invites scrutiny into the functioning of the courts. For some, the constitutional courts in India are among the most powerful in the world. For others, we are straying from our constitutional duties, sometimes by falling to challenge the status quo or in resisting the transient popular mandate of the electorate. As judges, perspectives and critique matter because our foremost duty is towards the public, and secondly, being open and transparent is the biggest strength of the judiciary. As adjudicators, we eschew any sense of being beyond reproach. In being responsive to constructive feedback, our courts become more efficient, citizens and public-centric and accountable. By opening ourselves to scrutiny, we can identify systematic inefficiencies and bottlenecks and work towards eliminating them. However, sometimes critics question, how can an unelected judiciary justify its significant power in a democracy? But imagine a world where judges campaign for rules, solicit views, decisions from public, and make promises for future judgments. The Constitution, by design, insulates the judiciary from the ebbs and flows of the electoral process. This ensures that its decisions are unbiased, without any fiction or ill will, free from external pressures, and guided solely by the Constitution and the laws. At the same time, each branch of the government is not a satellite independent or in an independent orbit, but rather a related actor which works in a degree of separateness. There is interdependence, autonomy, as well reciprocity. Each branch must honor its constitutionally assigned distinct role while nurturing interinstitutional equilibrium. When properly understood, judicial independence serves not as a high wall but as a bridge catalyzing the nurturing of the Constitution, fundamental rights, and the governance framework. When a citizen challenges a law or an executive action, they participate in the democratic process as envisaged by the Constitution. The judiciary becomes an arena where ideas of our republic are continuously tested, refined, affirmed, or molded. I would like to highlight certain areas of concern which are today engulfing the judiciary. These are areas and backlog of cases, delays, cost of litigation, excess and lack of ease of access to justice, large number of under-trial prisoners, and phenomenon what I term is want of truth or truth deficit. I will not like to highlight each one of them, but focus on 2-3. To begin, the scale of cases flowing into the Indian courts is staggering. This year alone, our judicial system received over 2.8 thousand crore cases in the district courts and about 16.6 lakh cases in the High Court and around 54,000 cases in the Supreme Court. Therefore, it is not surprising that there are more than 4.54 crore cases pending in the district courts and 61 lakh cases pending in the high courts. These numbers reflect the challenge, and yet they represent deep trust citizens place on our courts as ultimate arbiters of justice. Our district courts have shown remarkable improvement in efficiency, particularly in civil matters. The case clearance rate, a key metric of judicial productivity, has risen steadily from 98.29% in 2022 to impressive 101.74% in 2024. Last year alone, our district courts resolved over 20 lakh criminal cases and more than 8 lakh civil cases. The Supreme Court, too, has enhanced its performance, with our case clearance rate climbing from 95% to 97%. These improvements, while encouraging, remind us that our journey towards efficient justice system is ongoing and a lot of steps have still to be taken. We must also thank the Government of India, which had approved Rs 7,200 crores for Phase 3 of the E-Court project, ensuring that the judiciary is equipped to perform its core functions. Real-time transcription and speech-to-text tools by the Supreme Court and now by some of the district courts attempt to address the issue of truth deficit, improving justice delivery. The National Judicial Data Grid, a comprehensive repository of case and litigation details, aids policy formulation by providing insight into performance, appraisals, and infrastructure needs. We have often spoken about the need for judicial impact assessment at the time when the laws are enacted. However, there's another element of judicial impact assessment. This is in form of statistics and data in the grid for analyzing the laws and their implementation. In this data-driven era, availability of judicial statistics represents an untapped opportunity for conduct of thorough impact assessment and transform governance. Judicial impact assessment is a tool to identify, modify, repeal, reenact laws and their correction. It enables us to correct corrective steps where the law is burdensome for the people to follow or implementation is problematic. For example, the backlog of check bouncing cases in our district courts have reached an alarming portion, nearly 9% of the cases pending in the trial court. Data also reveals plea bargaining has been a non-starter, compounding and probation have not gained acceptance. Perhaps these require legislative interference. Two statistics reveal an insightful contrast in our judicial system. While current prison population stands at 5.23 lakh prisoners, our judicial workforce comprises of about 20,000 judges and judicial officers in the district level, and about 750 judges in the High Court. This vast disparity for those seeking justice and those tasked with dispensing it should typically forecast a paralyzed system. Yet data tells a different story. In 2022, in spite of influx of 18 lakh new inmates, The judiciary facilitated release of about 15 lakh prisoners, out of which 3 lakh under trials were released within the first year, achieving 69% release rate. 2024 data further highlights this efficiency. By November 24, courts had released about 5.38 lakh prisoners, surpassing 5.29 new admissions.